Thank you very much, Professor Wakui. And thank you to Kyoto University for hosting me in person. It's wonderful to be here. I just had a short walk around the city and was already mesmerized. And thanks also to Ascola Asia for hosting this seminar and roundtable discussion on experimentalist competition law. Um, and whether or not, I guess the question that I want to discuss with the participants in this moment in which there is some uncertainty about actually the future and the viability of competition law as a regulatory tool, whether the experimentalist approach to implementing competition law can show some promise. Now, I should also say that I'm more than welcome to be interrupted by questions, but a number of the participants are in fact online. So it may be best that I kind of keep going, with a presentation, and then I might stop for questions. Okay. So in terms of my own work on experimentalist competition law, it has gone over a long period of time. I first was attracted to the idea of experimentalist governance as a model through which competition law can be implemented back in 2007 when I was still a doctoral student, and when the case in vogue that everybody was talking about was the Microsoft case. And in fact, as some of you would know, people who still remember or care to think about the Microsoft case, it had a number of different iterations in different jurisdictions, and sometimes more than one in a particular jurisdiction. And what I noticed at the time was that many of the remedial mechanisms that were being implemented in that case resembled the remedial mechanisms that were used in reforming public institutions, which is where the model of experimentalist governance, first started to have some sort of both practical and theoretical attraction. So things like reforming failing state institutions like prisons, like child welfare institutions. So large institutions that were set in their ways and that were very, very difficult to reform. And so that's kind of where experimentalist governance was originally born. But I saw that there were many parallels in the remedial mechanisms in Microsoft and in the models of experimentalist governance that I was observed that were being discussed elsewhere. And then eventually, a few years ago, I published a book on experimentalist competition law, which essentially tries to rationalize the evolution of the European Union, a set of European Union developments, both through devolution of competition enforcement towards the member states, but also the use of remedial practices that were commitments-based and which were oriented towards problem solving rather than finding liability. So in my book of a few years ago, which was based on a project that I was part of while I was living and working in Europe, tried to essentially say, look, there is a set of developments in the European Union, in the way in which competition law is implemented in the European Union, that can be understood as the formalization of experimentalist governance. And the aim of, I guess, our discussion today is to say, well, does this have, some more way to go? Does it offer actually a promising way to think about, for example, the way in which competition law can confront the challenges of, digital platform regulation, artificial intelligence regulation, or on the other side, the accommodation of different types of objectives in competition law, whether sustainability related, whether labor market related, and so on and so forth. And my argument will be that competition law experimentalist competition law could be a promising way forward. And my book talks about not only how we can understand existing practice through an experimentalist lens, but if we accept that experimentalist competition law is desirable, how you can, how you can implement reforms that can make it kind of more experimentalist. Okay, so it's both, my book is both in a way descriptive and theoretical. It tries to say what's going on can be understood as experimentalist practice, but it can also be done better. And so I offer also some suggestions about, how can you transform even slightly models of judicial review, for example, in order to make practice more experimentalist. Okay, so that's a little bit about the history of the idea, my own history with the idea, and kind of, my claim of what I want to claim today. By way of my talk, what I plan to do is first to talk about the key features of experimentalist regulation in a very, very synthetic way. Then I want to talk about the reasons why you might see experimentalist regulatory architectures being used, even when people are not really thinking about them in an experimentalist way, but they're trying to overcome some problems, and what they come up with essentially amounts to experimentalism. Then I will talk about kind of what's a full experimentalist architecture for implementing any type of regulation, including competition law. And then I'll talk about some specific experimentalist techniques. What can you use if you decide one day, you wake up in a competition agency and you say, I want to be more consciously, self-consciously experimentalist. What is it that I can use in order to, to do that? And then I'm going to talk about examples. And let's see how we go with time. I might actually stop before the examples to take some questions, and if people have any, and then maybe I'll discuss the examples by way of answering questions as well. That's one way to do it. All right. So what are some of the key features of experimentalist regulation? And you will see, and I will come back to this point later on in my presentation, that a number of these things are not unique to experimentalist governance. Many models of what's called new governance as an alternative to top-down command and control regulation have some of these features, but an experimentalist architecture puts them together in a specific kind of way and with a specific orientation and objective. So the first feature is that the implementation, let's say, of experimentalist competition law is done through concrete problem solving rather than through law enforcement. So you're not trying to enforce the law to attack specific conduct that you know is illegal, but you're saying, what's the problem here? What's the harm? And can we somehow address that harm in a kind of collaborative way? So the focus is on implementing remedies for identified blockages and harms in the market, rather than to develop rules of liability that can help public or private ex post enforcement. So you kind of want to attack the potential problematic conduct already in its incipience and try to address concerns that people might have about why it's harmful to them, rather than to kind of like, have a rule, very, very clear rule about what conduct is illegal and what conduct is not, is legal. So the focus when you're designing remedies in experimentalist competition law is to create a participative mechanism for error correction of the remedy, not to optimally design the best possible remedy. You say, well, we're not going to get it right. Let's start with something and have a process through which we can correct it over time. Now, again, these are common to other models as well. Then there is the next step, which is, well, this looks like discretionary implementation by a competition agency. How do you ensure that there is accountability and efficacy? And you do that through peer review of the design and of the effect of specific interventions or remedies, okay? So you don't control discretion through rules, but you control it through peer review, both of the design of the remedy and of the effects of the remedy over time. And who are the peers? Well, the peers are not just, potentially they can be other competition agencies if you're part of a competition network. It can be sort of, a more informal type of peer review in kind of, in interactions between competition agencies, even if you're not in a network. So in Europe, they have a very formalized system of peer review, which actually is required for taking any action. Decisions just go to the other agencies as a matter of course. So that's why in Europe, it's easiest to see this architecture, but it happens also in other settings as well. And also the peers are also the market stakeholders because they're affected by the remedy. They're the ones who start complaining if something is not working. So, when the Google Shopping remedy was implemented, even though it was actually a violation remedy, already a year later, market stakeholders were saying, this is not working, it's not, we need something else. So you have two types of peers, both agency peers and market peers. And then the idea, the last element is that you have different implementation, and this is where the experimentalism idea comes from. You have different implementation solutions being trialed in different settings, and each of them is they're basically trying to learn from each other about, what things might work and what things might not work. So that's the kind of where the all of these elements which are seen in various models of new governance, they're put together in the idea that we actually try to learn from differential implementation of competition law in specific settings to address different kinds of problems, which might be common but might be different. Even the same conduct by the same company, take, I don't know, Google or Amazon, will actually have differential impacts often in different industries and even in different countries because the significance of that conduct and the market environment would be different. And so, the idea that you can come up with an ideal rule is very, very, I think, pretty much impossible. So that's basically kind of the key features of the architecture. Now, my second question for the purposes of today's discussion is why would you use an experimentalist architecture? And here I want to say that sometimes some enforcement agencies have themselves said, look, experimentalism is the way to go in competition law. So in my book, I cite a talk by the head of the Bundeskartellamt in Germany, Mund, from some years ago, where he says, look, competition law is at a crossroads, and we really need to be thinking about it from a more experimentalist perspective. But more often, rather than conscious experimentalism, what the competition agencies will be doing is they'll be trying to overcome certain problems. And in trying to find a workaround, a solution to a particular problem, they will implement a mechanism which, if you stand back and if you look at it through the prism that I've been talking about so far, you will say, oh, what they're trying to do is they're trying to learn by doing, but also by comparing to what others are doing. So in fact, they're creating an experimentalist mechanism, even if they're not actually very self-conscious that that's what they're doing. And so what are the problems that usually are faced by competition agencies that lead them to sometimes formalize solutions that have an experimentalist character? The most important one is when they face uncertainty about the selection of instruments, both rules and remedies, in order to achieve specified objectives, whether those objectives are consumer welfare or you define them more broadly. If it is difficult ex ante to come up with both rules and remedies that achieve the goals that we want to achieve, we're faced with a problem. You necessarily have to enforce in a very suboptimal way, because the rules will be rough guides to what's negative conduct, and then the remedies will not always be particularly well tailored to achieve the objective that you're trying to achieve. Now, when much of the world started to move from a rule-based to an effects-based competition policy from the 70s onwards, this problem was already recognized. The idea that we could come up with easy per se rules which said this is illegal, kind of started to become a bit problematic, because a lot of these things could be understood as, a lot of conduct could be understood as, efficient responses to certain market features. And so, the per se list started to shrink. Everything else was supposed to be assessed by reference to effects, and the effects often were ex ante uncertain. Now, so long as we believed that economics could be good enough to predict the market effects of conduct in various counterfactuals, we could adopt what we might call a technocratic competition policy, where we said, okay, there are no legal rules, but we can trust economists to sort of work out what the effects are going to be, and that's what's going to tell us what we're going to attack, what we're not. The problem is that, economics in static contexts, where a market is very stable over long periods of time and is unlikely to change, does have some pretty good rules to tell us, to model the effects of particular conduct. The more dynamic the market is, and the more you can't really predict the future of the market from the past of the market, economics doesn't really have very good tools to assess effects. And in fact, even economics has been moving much more towards, becoming an experimental science, where, in order to understand, effects and causality, economists increasingly themselves use experiments. But you will see that using experiments and using experimentalism, they're different ideas, and I'll come back to that in a moment. So once basically now all of the major concerns that we have in competition policy are not in the static markets, stable markets, but in the markets that are highly unpredictable and dynamic. Even economists themselves say, look, we don't really have the tools to tell you what the effects are going to be, okay? Now, there is also uncertainty, and this is increasingly being talked about because, competition policy implemented in a particular way might have unintended consequences and policy trade-offs for other policy goals that we have. Increasingly, we're not able to treat these things in silos. So, a competition intervention will have direct, effects on data privacy for the users. It will have direct effects on infrastructure maintenance if you're going to allow access to infrastructure to other parties. It will have effects on labor markets, on sustainability. And, it's increasingly thought to be problematic to ignore those effects when you're making competition law decision making. If you accept that competition law should be targeted to different objectives, then I would argue nothing but experimentalist competition law can work, because you cannot develop rules that effectively balance these different kinds of objectives. Already trying to target competition rules to, say, consumer welfare effects is difficult. If you're going to get other things in, you must have a novel institutional idea about how you decide in competition law. You cannot do it in the traditional way. And then on top of that, you can add, and I discussed this in the book, ideas of precaution entering into competition law thinking. So they started to enter into competition law thinking once we were talking about the problem of the tipping points of platforms and their irreversible entrenchment. Okay, so people sometimes argued, once you reach a tipping point in markets with network effects, maybe you reach a point of irreversible entrenchment. So you must somehow intervene early on, but we don't know how, and we don't know what the limit of that intervention is. So already there, people started to talk about precaution in the context of competition law, which previously we didn't talk about. We thought precaution was about environmental disasters, things like that. But as I try to point out in the book, it actually starts to enter into the thinking in competition law. And now, of course, people's concerns about irreversible effects with AI are also making us think about precaution. And precaution is inherently, it's about uncertainty. You're not sure if some negative effect is going to result, but you're really, really worried about the effects of that if it's going to result. And you don't know, other than just saying no to the technology, you don't know what else you can do to reduce the likelihood of the catastrophic effects. So either we have to accept to say, okay, this technology, we're just not going to accept it anymore. Or we have to say, is there some way to let it go and develop, but make sure that we have some kind of ongoing ability to learn so that we can kind of identify whether we're getting towards a point where we need to be really worried about it, okay? And so when you face this kind of uncertainty, it's very difficult for you to kind of, to do what? So my second question there is, who faces this uncertainty? Well, the uncertainty is faced by legislators when they try to write rules for competition law, either for ex ante regulation or ex post competition law. So in many jurisdictions, including Australia, books about, for example, new platform rules, laws have been kind of contemplated now for 3-4 years. And, the legislators are kind of sitting on them and they're just not sure what to do, okay? They kind of feel that they need to intervene because people are worried about these things, but they also don't want to kind of like, stop the beneficial development of the technology. And so in many countries, you sort of have a stalemate. Same thing goes with enforcers. So many enforcement agencies around the world could already use existing competition rules to attack some of the conduct that's been observed. And we see that having been done, especially by the larger jurisdictions like the United States and the EU. They could use existing competition rules. But even there, it takes a very, very long time for agencies to kind of say, okay, this particular conduct we select as the problematic one. And even there, if you look at the US cases, suppose that, the US cases, for example, against Google, suppose that they were well selected. I'm not going to dispute whether they are or they're not. The remedial uncertainty is very big. So nobody really knows what do we do now? I mean, they have requested, for example, that Google sell Chrome, but is anybody going to buy Chrome without, and how is that really going to be a competitive constraint in the future? Is there some way that we can implement that remedy to make sure that that is in fact the effect? So legislators face the uncertainty, enforcers face the uncertainty both in selecting which conduct is problematic to attack and then how to remedy it. And then transnational actors, like the International Competition Network, UNCTAD, or even the European Union, face uncertainty in proposing rules and enforcement mechanisms that member jurisdictions should follow. Okay. Particularly if local contexts could be different and conduct could have differential effects. And, my understanding, for example, is that a lot of the platform conduct, that has attracted attention, for example, in many Asian jurisdictions, it just has very different effects to the ones that have been kind of mainly talked about in, let's say, the hegemonic jurisdictions like the US and the EU. And then there is a second problem, which is sometimes, even in the face of uncertainty, some actor will decide, okay, it's true, I'm uncertain, but I've identified my preferred solution and I'll just now go ahead with it, right? Of course, nothing is perfect. I'm uncertain, but I think I'm going to go down this path. The problem there is that, if you try to implement solutions hierarchically in a top-down way, all of the regulation and governance and socio-legal literature on regulation tells us that's very, very difficult, okay? Because you need to constantly be monitoring what's going on by the regulated entities. The regulated entities will try to escape your rules, and you will need to constantly be monitoring the market. So unless you get the regulated entities to be helping you in some way in the regulatory exercise, you're constantly going to be chasing one sort of, conduct after the other, because they'll try to kind of essentially escape from the clutches of what you've identified. And in fact, some people argue, for instance, that what's going in the European Union with the implementation of the Digital Markets Act is a little bit an illustration of that problem. So the European Union said, okay, even in the face of uncertainty, we've identified a set of obligations that we think we should impose on, digital platforms. And we will impose those, but, some of the reports of, difficulties in implementation, you might think of as the difficulties of hierarchical enforcement. If you're going to try to impose rules in a top-down way, without the collaboration of those that you're regulating, they will basically try to escape the scope of the rules. And so in the experimentalist literature, this is sometimes called, a situation of polyarchy, or I prefer to call it the limits of hierarchy. When you're not able to easily hierarchically implement preferred solutions, in a way, you become forced to start more collaborative kind of conversations with your regulated entities. Okay, so both the uncertainty problem and the limits of hierarchy problem kind of drive you towards saying, look, rather than enforcing rules in the traditional way, I need to kind of problem solve in a different way. And if you read most of the reports of the agencies, which kind of try to identify why it is that they want to, for example, move from ex post competition law to ex ante regulation in digital platforms, they basically talk about uncertainty and the limits of hierarchy. They talk about, well, we can't really tell when some conduct is going to have negative effects. Therefore, we need to exercise some kind of precaution. And when we do it through the courts, the need for time, for evidence, for kind of, the adversarial process takes such a long time that by the time we've basically had the case decided, like the world has moved on and the problem is no longer there. So we kind of need to be more agile. I mean, what the agencies are there talking about, even though they're not using the words of uncertainty and the limits of hierarchy, that's what they're talking about. We don't know which conduct to target, and by the time we target it, and by the time we go through the hierarchical procedure of enforcement, the world has moved on and the case kind of loses its significance, okay? And so if that's what the problem is, and we had this discussion in Australia when our agency, the ACCC, was kind of saying, okay, so what should we do now? In the consultations, I said, well, look, the problems that you've identified are uncertainty and the limits of hierarchy. The solution to those problems, one solution is experimentalism, but they, like many others, preferred to go down the route of ex-ante regulation, which means that you have to come up with some kind of rules that are applicable across different platforms and that are somehow well targeted to conduct that is problematic, and then to be able to enforce those rules by really closely monitoring these entities rather than engaging them in your regulatory endeavor. So that's on why to use experimentalist governance mechanisms. So then the next thing that I wanted to discuss is, well, what is a full experimentalist architecture? Okay. And so if you kind of say, well, okay, there are these sort of there are these reasons why you might want to use experimentalism, and experimentalism has a lot of common traits with some other regulatory theories, like, those of you who have worked on the work of Malcolm Sparrow, who talks about problem solving, mechanisms in regulation. So there's clearly some sort of alignment with that, but he identifies problems as essentially kind of risk-based regulation, which is technocratic. You just find the experts who can tell you what the risks are. And in the past, in competition law, we could rely on economists, but now they're kind of not really very, very good at telling us, where the uncertainties about future harms are. And so instead of, what would a full experimentalist architecture look like? So the first step is, assuming that you're working in a system where there is kind of a goal setter, like a parliament, or like which basically sets the general rules within which a certain regulatory regime operates. The experimentalist approach would be that and this is not actually uncommon, that the overall framework sets some common objectives to be pursued by lower level actors. Okay, so rather than trying to actually specify the rules, it says, well, these are the kinds of objectives that we need to be pursuing through this regulatory instrument, say competition law. Then the second element is to allow autonomy to lower level actors to select their own instruments, both rules and remedies, about how to achieve those common goals. Now, you might immediately say, well, who are the common lower level actors who have autonomy? So, in a transnational regime like the European Union, the lower level actors could be national legislators or even enforcement agencies. So until a few years ago, for example, most members of the European Union had the same competition rules as the EU. Actually, as of recently, as the concerns about digital markets start to emerge, some countries have even started to introduce their own kind of specific rules on digital markets, which are not mirroring those in the treaty. Okay, so you could have that. In any event, you can also have lower level enforcement agencies, national enforcement agencies, essentially pursuing the same objectives, but saying, look, we're going to, tailor the solutions to the specific context that we are addressing. And sometimes when there are cross-border effects, you need to think about how you can cabin that so that, one remedy is not undermining the remedy pursued by somebody else. But there are ways to do that. If you look at some of the examples in the book, you will see that it's actually not impossible to do. And you can also have companies who are subject to regulation. So the regulatory target companies also be pursuing different, remedies for or different solutions to particular problems that have been identified in their conduct. So there is no need, for example, to assume that to a search or an app monopolist like Google, you would be applying the same kinds of rules and remedies as to a kind of marketplace like Amazon. The generic idea of competition law always assumes that the rules and the remedies have to operate across different contexts in the same way. And actually, there is no reason for that, both because the harm may be different, but also because there might be scope for learning by pursuing one type of remedy in one context and one type of remedy in another. Now, of course, that's concerning because it does involve a lot of discretion for competition agencies. And, I've seen already today expressed concerns in the media about, giving a lot of discretion to competition agencies under these sort of, conditions. And so you need to discipline them. And the disciplining mechanism in experimentalism is peer review of the local interventions, both the design of those interventions and the effect of the remedies, which are monitored over time in a peer context, okay? And so here the idea is not that you are basically learning what Japan is doing so you can transplant it to, I don't know, Korea or to Thailand, but you're learning from each other's implementation efforts. And some things might be transferable across jurisdictions and other things might not be. The goal is not to converge on the same solution, but everybody, by doing it at the same time, to actually be able to have more informed conversations with their peers, rather than what happens with the transplant model, where, when you go to an ICN meeting, there are certain people who talk and there are certain people who listen. And that's not the idea of experimentalism. If everybody is doing it, but doing it in their own way, they can actually have more meaningful conversations with each other. And I have a project at the moment on the use of peer review in financial regulation. And I can tell you that, it really does qualitatively change the nature of the conversation when people are actually all engaged in some kind of a regulatory activity, rather than when they just sort of say, oh, well, tell me which rules to copy and I'll just download them in my domestic legislation, which generally doesn't tend to work. So the important thing here is that there is also peer review from market stakeholders. So in the European Union, for example, if you implement certain remedies, you have to subject them to market testing. And this then goes on with monitoring of the remedy itself. So many remedies in the EU are concluded with what is called a monitoring trustee, which basically means that you're creating either an independent or a peer-based mechanism that's monitoring the effect of the remedy over time, so that if people are not happy with the conduct of the monopolist, they don't have to restart the litigation tool. They have somewhere where they can go to and say, look, this is not working. Give us a solution. So what you can see is, by kind of having this ex post monitoring of remedies, experimentalism dissolves the distinction between ex ante and ex post, ex ante regulation and ex post enforcement. And so, that's why I'm a little bit troubled by all of this kind of discussion. Oh, should we have ex ante? Should we have ex ante, or should we rely on ex post? Well, neither is perfect if you cannot come up with rules that identify what the conduct obligations are. If you could come up with conduct obligation rules, whether it was ex ante or ex post, it wouldn't matter. But if you can't, then again, whether it's ex ante or ex post doesn't matter. You have to find some way to kind of resolve the uncertainty, but not just by saying either we're going to stop the conduct altogether or we're just going to let it run and then whatever happens, happens, but through some kind of a way that enables also public and regulatory actors to learn. Okay, so my final slide before my examples is on specific examples of experimentalist techniques. Okay, so how is this actually implemented? Again, the idea of kind of setting framework rules which sets out the objectives, many countries have kind of converged on this already. So, if you think about even the main, hegemonic jurisdictions, the US and the EU, essentially their rules have kind of now become effects-based rules in practice. There is some room for kind of, per se rules, but it's very, very limited. And so, the the rules basically say allow conduct which has good effects in the market, whatever we define those good effects to be, and don't allow conduct which has bad effects. And similarly, in Australia, for example, apart from cartels, almost all other conduct is based on a substantial limiting of competition test, which of course at the moment is understood as being focused on consumer welfare, but it doesn't have to be, right? It's just the way that it's been interpreted for historical reasons. So, what I say there is this idea of polycentricity that, some are arguing for is entirely compatible with experimentalism. And actually, I would say that if you want polycentric competition law, pretty much you have to really think about novel institutions, and experimentalism is what kind of, really tries to give you a framework to think about how you can design these novel institutions. So that's about the general rules. Okay, they should be objective based, and it can be limited, but it doesn't have to be limited. The second is that you enforce through what in the new governance literature is called regulatory conversations or management-based regulation, where you're basically telling companies you should implement measures that promote this objective. But it does so in ways that improve regulatory efficacy and accountability. So in the existing literature and practice, you will see things like, for instance, principles-based regulation, whereby the regulatory framework provides certain principles that then industries or firms have to implement through their own actions, okay? That's consistent with experimentalism, but if all of your firms in the industry are adopting the same solution and you have no way of learning which solution is effective and which is not, you get the banking crisis of 2007 and 2008. Because there, many countries were adopting principles-based regulation, saying, you should implement firm practices that promote these objectives, but everybody was doing exactly the same thing. Everybody was valuing their assets at this and having them assessed by the same credit rating agencies. And so if everybody is doing the same thing, you're really down the path, not of experimentalism, but of catastrophe, because you're locked into one model and you can't learn about which instruments are better at promoting the goals than others. The other type of mechanism is commitment-based remedies. So, this is the idea that you negotiate the remedies with the entity. But, as I've argued in my own work, this is not about settling the case. But, what happens in Europe is that the commitment remedy often only starts the conversation because it then creates a monitoring trustee that has an ongoing role in overseeing the remedy. And interestingly, what we've seen in some jurisdictions is in this monitoring mechanism, incorporating regulators from other regulatory silos if there are effects that could be if there are effects that would affect other objectives of public policy. So in Europe, there are examples where the monitoring trustee might involve the national energy regulators because the commitment remedy has been implemented in an energy sector, or data protection regulators can be incorporated in the monitoring trustee because there are effects on data. So rather than bringing in-house expertise and turning the competition regulator into a regulator for everything, you actually create these multi-platform monitoring mechanisms that bring in different kinds of expertise, including regulatory expertise. Regulatory sandboxes, where you say, okay, we'll allow you to pursue that innovation, but subject to monitoring about its effects. Again, sometimes these things are treated as experiments. The experimentalists among us would say you can't really have natural experiments in the social world because you can't really control for things. But what you need is a participative mechanism of observing the effects and monitoring the sandbox. So if it's a closed sandbox that involves just a regulator and the entity that's implementing the conduct, that's not very experimentalist. But if it's kind of like, if it's a more open sandbox, which basically tries to get as much peer input as possible in this innovation, then that does look more experimentalist. And then importantly here is this idea of peer review, which is not technocratic peer review the way we understand it in the academia, where the top experts are saying, do you know the existing knowledge or not? Peer review is more about kind of a conversation among peers who are engaged in the same kind of activity, and they're not just agencies, but also stakeholders. Importantly, and this is again consistent with some other strands of thought that are current at the moment. You need to think about the dynamic adjustment of remedies over time. So you're not trying for any sort of optimality, either in rules and remedies, but how can I create a participative mechanism through which the remedy that we've implemented, that we know for sure is not going to be 100% effective, can become more effective with time. And again, here, if you're familiar with the literature on responsive regulation, that literature says that, the enforcement agency should start by being kind of a bit more lenient with, with entities. And then if they're not listening to what they're supposed to do, you sort of ratchet it up to kind of, fines and penalties. Here in experimentalism, you're not lenient. You're just saying, look, if a lighter remedy is going to work, like disclosure, we can try that. But if we observe in the market that a disclosure remedy is not working, we then have to try something more. So it's not that you're becoming more punitive, but as you found out that certain lighter remedies are not working, you actually sort of start to go for more interventionist remedies. And nicely there, you're creating the incentive for the company to make the less interventionist remedy work. Because if there is different kinds of disclosure, there is real disclosure and there is fake disclosure. So if you're going to say, look, we're going to leave it with disclosure, but if it works, maybe the company will implement, in fact, a disclosure remedy that works. And then finally, you might have a penalty default, which is actually a hierarchical remedy that operates in the background and says, look, if our collaborative problem solving cannot get off the ground and create a workable remedial mechanism, yeah, we're going to go to court. And maybe we can even impose fines as part of that. But nobody wants that remedy. So in experimentalism, even the agency doesn't really want to go down that path, either because it's more difficult to establish your case, but also because you lose the ability to actually correct the conduct. Once it goes to court, basically the court has the final word. So it's okay to have and sometimes it can be helpful to have a hierarchical mechanism operating in the background in experimentalism, but so long as it's a hierarchical mechanism that nobody wants. If instead the agency perceives its ultimate goal to collect as much in fines as possible, it's not going to be very interested in acting in an experimentalist way. So maybe since it's now almost 4, there's a bunch of examples and some, more reading on that page. But maybe I should, I don't know until what time we have, but maybe it might be a good idea to allow for some questions. And then as part of that, I might mention some of these examples here. Is that, until when do we have? Oh, another 40 minutes. Oh, okay. Well, maybe I can sort of go through these and just very briefly. The reason I want to just spend a little bit of time talking about this is because I don't want you to be thinking that what I'm doing in this book is saying, I've got a newfangled theory, and wouldn't it be nice if competition law was like this? Okay, my book essentially tries to say, if you look at important examples of enforcement across different jurisdictions, they face the problem of uncertainty and the limits of hierarchical enforcement, and they solve them through mechanisms that look experimentalist, but sometimes they don't encompass the full experimentalist architecture. And that might actually sometimes also make them a bit less effective. And so I've got both a descriptive claim where I say, I'm looking at examples and I'm saying what they're doing, even when they're not actually saying we're experimentalists, is trying to create an experimentalist mechanism. And if they were self-conscious about it, and if they thought about the entire architecture, they would be doing their job better. So I kind of also have a normative dimension there. And so, as I told you, this all started with, when I was doing my doctoral thesis, when everybody was talking about Microsoft. And what you had there was, multiple jurisdictions, and sometimes even in the same jurisdiction. In the United States, for example, the Federal Department of Justice was pursuing its own case, and the state's attorney general pursuing their own case. And in their different litigation, they were pursuing different kinds of remedies. And the judgment in that case has a very, very extensive discussion about the likely efficacy of different remedial mechanisms. Nobody paid attention to this part of the judgment because everybody was interested in, you know, was Microsoft guilty or not guilty of anti-competitive conduct? But if you look at actually the decision about the remedy, which basically assesses the different remedial options, it's very, very interesting read. Okay. And that's where I kind of started to pick up on the similarities in thinking between these other settings where experimentalism was used, like, as I told you, prisons, child welfare agencies, and a company like Microsoft. And then what happened was that the European case came along, and there is an element of, well, we saw the remedy that was implemented in the United States, and we saw that it did not actually lead to, for example, the licensing of interoperability operation to work group servers. And so we need to go with an obligation that's stronger because what was done in the United States didn't work. Okay. And so there you have kind of like, a sort of an emergent experimentalist idea that, we tried once, that didn't work. Now we're going to try something different, but we need to have learned from the previous example and how we implement this one. Um, um, a second very common type of argument that is made, especially in cases where there is a request for access to some kind of infrastructure, is that, well, you can't allow the infrastructure access to be for free, so you have to set the price. And then in addition, how are you going to deal with the fact that sometimes the users might essentially degrade the infrastructure? Who's going to control this? Who's going to oversee this? Where is the limiting point? In a commitment decision that the European Union implemented in a case called Real Alcan, they very interestingly created it was a commitment remedy where the owner of a technology was basically mandated to share that technology with downstream users of that technology because it had its own downstream operation as well. But then it was subject to a monitoring mechanism that was essentially both defining what type of users can be allowed access to the infrastructure and monitoring the way in which those users were accessing that infrastructure in order to be able to assess whether they were in fact degrading the quality of the infrastructure. Oftentimes, these kind of access cases is like, oh, well, we're not going to, the infrastructure owner will say, oh, if we let people, they're just going to basically degrade our infrastructure. And, this is basically saying, well, let's put that to the test. Let's create a mechanism that basically distinguishes who can have access and who can't, and actually observes whether there is a degradation of that infrastructure or not. Similarly, in collaborations that promote sustainability goals, this has been very, very tricky. So, the case that I discuss in the book is the case of sustainable chicken farming practices in the Netherlands, where nobody was essentially able to come up with, what does sustainable chicken farming practice mean, and how much is it valued by people, by consumers. And of course, 8 supermarket chains came together to, develop their own standards for sustainable chicken farming, and this had to be vetted by the competition authority as a potential anti-competitive arrangement. So, who can determine what are sustainable chicken farming practices and how much are they valued? The competition authority in the Netherlands first went to Wageningen University to say, well, can you do a study for us about how much people value sustainable chicken? And of course, that didn't come out to be very, very high, on a willingness to pay assessment, because, people didn't even know what this sustainable chicken was. And, so certainly they weren't willing to pay a lot more money for this chicken where they didn't even know what it was. So then the competition authority said, well, we have no way of deciding what's sustainable chicken farming practices. This is something that the government or the legislature should do. But the legislature didn't want to do it because they didn't know what sustainable chicken farming practices are either. So the solution that the competition authority in the Netherlands came up with was a very, very experimentalist one, even though I'm not sure whether they thought about it this way. They said, well, at the moment, we don't have enough information about what is sustainable chicken and how much people value it. So we can't allow your collaboration to set the standards among all of the main supermarket chains in the Netherlands for this. But that doesn't mean that, it will never be possible to have such standards. It just means that on the current state of knowledge, we cannot allow your collaboration. But we're open to a different kind of, knowledge framework to lead to a different outcome. And so that essentially means that you're kind of creating the scope for different stakeholders, and not just the supermarkets, but also chicken farmers, to bring together the necessary information framework that would allow some kind of sustainability coordination. Same thing about incorporating multiple and novel goals into competition decision making. I mean, I have a paper from a number of years ago on the Chinese competition enforcement. And in the early days of Chinese competition enforcement, where they were quite open about what kind of tool this was, we have 3 case studies in which, in early cases, the Chinese authorities considered the kinds of effects that now are regarded as kind of leading edge thinking in competition law. In the famous Coca-Cola merger, they considered the effect of the merger on labor practices because of the kinds of labor practices that Coca-Cola had in its own factories in China. In another case, they considered the effects of what would happen if a private equity firm bought out a state-owned enterprise, and the ways in which private equity owners basically deal with the assets of a target company. And in a third case, they considered the effect of certain practices of licensing on the ability of the local TV manufacturers to innovate. So all of these things are now considered to be kind of leading edge thinking in competition law, but they kind of already were considering them early on because they had no big preconceptions about what this competition law is about. And then finally, this idea that, you have to always look for ways in which you can institutionalize ex post peer review. So this is not peer review just before you intervene, but also to monitor the intervention, the remedy itself, and to learn from the implementation of the remedy. So maybe that's a good place for me to stop and to take some questions.